all set to proceed with State versus Ian Freeman?
Yes, sir.
No, I put in a motion to continue this hearing today, put that in a week ago. But I would like to have a motion, or I would like to change this into a hearing on the actual administrative inspection warrant, if that's possible. So I've been interested in challenging the legitimacy of that since I was aware of it last year.
So you're withdrawing your motion to continue the hearing then?
The hearing today was supposed to be a full trial, and I would like to continue the full trial. But I would like to have a hearing regarding the administrative inspection warrant, which began this whole process in the first place.
Yeah, a couple of things, Your Honor. There's another motion outstanding that the court will need to deal with. It came on early in the case. It was a motion to dismiss based upon a constitutional provision. The court's order was that it would be dealt with at the time of trial. I don't know if the court wants to deal with that this morning.
Which motion is that, Tom?
In my docket, that was number 5. It came in on February 7, 2013, and it was titled the motion to dismiss, and it cited Article 10 of the state constitution. So that's one matter still before the court. With respect to the continuance, we would object to the continuance. Mr. Bernard, I know Mr. Bernard prefers to go by Freeman. I'll let the court decide which should be addressed. But he's requested a continuance. He's obviously here this morning. With respect to the motion on the administrative inspection warrant, we did file an objection to that. We don't believe there's any basis for that at this point. And issues with respect to the administrative inspection warrant would be something that would be on the facts that are presented before the court on the motion on the request to enforce the city ordinance.
Well, I guess, Mr. Freeman, the question is, do you go by Freeman or
Yes,
Bernard?
Ian Freeman, thank you.
Mr. Freeman, it sounds like there may be some factual information necessary to make a determination about your motion.
Which motion? I'm sorry, there's like 3 right now.
The motion for the hearing on your administrative inspection warrant.
Yeah.
Okay? What other motion besides the motion to continue are you talking about?
Well, he brought up the
The motion to dismiss, Your Honor.
from February 7th.
Is that a motion that is still pending?
Yes, Your Honor. The court issued an order on 3/15/2013. Court's order already motion to be addressed at trial. It's a handwritten note on the copy of the motion that was filed, Your Honor. It says to be addressed at trial. And I believe it was signed by Judge Burke, if I need the signature correctly. And we did file an objection to that.
Okay, I haven't reviewed that. I'm having a hard time locating it here in the file. Is that a motion that you're prepared to argue today, Mr. Freeman?
The motion to dismiss?
Yeah.
Sure, I'd be happy to
Okay, what was the basis for your motion to dismiss then?
Article 10, New Hampshire Constitution, the right of revolution. Are you familiar with it?
No.
Okay. Well, I'll share it with you. The right of revolution, government being instituted for the common benefit, protection, and security of the whole community, and not for the private interest or emolument of any one man, family, or class of men. Therefore, whenever the ends of government are perverted, and public liberty manifestly endangered, and all other means of redress are ineffectual, the people may, and of right, ought to reform the old or establish a new government. The doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. And
So how is that applicable to this situation?
well, I'm engaged in a peaceful revolution against the men and women calling themselves the city of Keene in this case, as well as the United States, the state of New Hampshire. As a believer in property rights, I believe I own my property. And as a landlord, I want my tenants to be happy and safe, feel safe living in their home. So I'll take steps that are necessary to achieve those goals. And I'm happy to listen to suggestions from people who are experts in fire safety in order to do that. However, I don't appreciate being threatened, and I will not accede to demands that I feel are ridiculous, expensive, and unnecessary, especially when I have my tenants agreeing with me. Now, Fire Chief Gary Lafreniere, who's a very nice gentleman sitting in the room here today, will testify that I did take steps to increase the fire safety in my tenants' homes.
Objection, Your Honor, I want to, if you'd like to do that.
Yeah, let's address your argument here first about the constitutional issue. Mr. Mullins, what do you want to say in response to that?
I did file an objection, Your Honor, that's in the record, if the court can't find it, but essentially, the position that the city takes with respect to Article 10 is that it's just not relevant or germane to the issue before the court. I did cite the case of Nelson B. Wyman, the Attorney General's, the Attorney General, 99 New Hampshire, 33, 1954. And as the court says in that, it's not a broad and unlimited right of insurrection and rebellion to permit any group which is dissatisfied with the existing government to lawfully attempt to overthrow the government by force of violence.
I'd like to
In that
object to
case,
that.
Well, hold on, Mr. Freeman, you had your chance. Just a moment. Mr. Mullins?
Your Honor, from the city's perspective, what we're talking about is an ordinance, city ordinance, based upon the life safety code, which has been adopted by the state. It's purely a regulatory issue. I would suspect and would hope that even in Mr. Freeman's society, should it come to fruition, that it would have an interest in protecting life and safety and have some sort of regulatory structure with respect to a fire code. That's what we're talking about. We're not talking about the political ramifications of political bodies before the court. That's basically what we're here for. We don't think the article is wrong.
Anything else, Mr. Freeman?
Yes, I'd like to object to his interpretation that I intend to overthrow anyone. I'm a peaceful person, and I have no intention to overthrow. But the basic gist of this motion, which I wasn't able to get through here, was that I've been targeted for my activism. I'm a known activist in the area here, and Fred Parcells, who is the man who brought some of this action against me, is with code enforcement in town. I've had a history with Fred that has been mostly pleasant on a personal basis, but ever since he was hired as code enforcer, he's been coming after me. And so I can look at the history of me owning this home in Keene. Prior to Fred being hired as code enforcement, I hadn't heard hide nor hair from code enforcement in years about my property. Then all of a sudden,
Your
when
Honor,
Fred
I'm
gets
going to
hired,
object. Mr. Parcells will be taking a stand, and to the extent that the court finds any of this relevant, we can have that discussion with the court.
the point is that the person, it seems like it's a vendetta against me for being an outspoken activist. And
Well, I
have a
don't know
long
anything
history.
about that at this point, Mr. Freeman, but if there's going to be evidence introduced on that subject, I'll certainly take that into account before ruling on the motion.
So do you
So
want-
I'm not going to rule on the motion at this point. I'll defer ruling on it until after I hear more.
Your Honor, I guess I would request some clarification with respect to that. I mean, I expect that Mr. Freeman will attempt to elicit testimony from Mr. Parcells with respect to what he thinks may have happened in the past. I'll certainly object to that. But to the extent that the court wants to have a full-blown hearing on whether Article 10 attaches to this, then I need to raise that question with the court.
We don't need to have a full-blown hearing on that. I will take into account what both of you have said about the applicability of the article. If there's anything that is produced by the testimony that reflects on that, I'll take it into account, but I don't think we need to hear any more about it.
Thank you.
Okay, so, Mr. Freeman, as far as the hearing on your motion for the administrative inspection warrant, do we need anything further about that before we start taking testimony on the underlying issue? On the trial of the underlying charge?
Well, yes. Regarding the administrative inspection warrant, it's my contention that it was issued in error, and that is based on RSA 153.14.2. This is one of your society's rules. It says that the fire chief may inspect all buildings, excluding single-family dwellings and multi-unit dwellings containing 2 units. Now, in the city's own, as you see in the motion there, the city's own notice of violation they issued me after they had gone through this warrant. They had come through my property and essentially raided my tenant's home. They indicated in their notice of violation that they still have the home classified as a single dwelling unit. So by statutes, by your statutes, the fire chief never should have been allowed to come in and inspect. The city's argument in their objection is that, well, we believe that you were running a lodging house, and so therefore the fire codes would apply. But the purpose of the warrant was to get in there so they could determine whether or not the lodging house was being operated. So they had not yet made the determination that a lodging house was being operated. The legal status of the household was never changed, and to my knowledge still has not been changed to a lodging house, nor could it be changed. I've ever been charged with running a lodging house or accused of running a lodging house. So they couldn't have come in, the judge, Mr. Burke in this case, could not have ordered the fire chief against statutes to do something that he's statutorily prohibited from doing.
Yes, Your Honor, and I will be submitting, I'm sure the court will take judicial notice of RSA 153. I do have a copy in the materials that will be submitted to the court. I think it's important for the court to note a couple of things. The notice of violation did state that Mr. Freeman's property has been, as far as the city is concerned at the time of the administrative inspection warrant, classified as a single-family residence. The information that will be testified to by the parties here on behalf of the city will indicate that the city had probable cause to believe that the property was not in fact being used for that purpose. Once it wasn't being used for that purpose, then that created a potential zoning violation. The issue with respect to the 153 does not allow the fire inspector to go into what is clearly established as a single-family home or multifamily home. The issue here was whether or not there was probable cause to believe that the property was being used outside of those two classifications. The administrative inspection warrant, as part of the materials we'll submit to the court, will be part of the testimony. That warrant that was submitted to the judge did include evidence sufficient for the court at that time to establish that the property was being used other than for its listed purpose. At that point, the fire inspector has the right to go in and make a determination as to whether or not it is actually being used in another manner than was permitted. And we would submit that the evidence will show that that was in fact the case, that it was not being used as it was being represented. So at that point, the judge issued the administrative inspection warrant. We went in for that purpose. The question for the administrative inspection warrant, as the judge is clearly aware, is not to make a determination in the front end as to whether or not a violation has occurred, but to present enough information to the court for a determination as to whether a warrant should be issued to determine whether or not there is a violation. The fact is that the administrative inspection warrant and the inspection that happened as a result of that had revealed that the property was in fact being used as a single-family home, we wouldn't be here.
Sounds like it depends on the facts then, Mr. Freeman.
Well, what it sounds like to me is that if they wanted to make the argument that they claimed in front of the court they had probable cause of lodging house happening at this particular location, they would have then been able to get an administrative inspection warrant to inspect for the purposes of determining whether a lodging house was actually occurring. So they had things that they believed were pointing to that, but they didn't have any real evidence or proof. And so the warrant, it would have made more sense had it simply authorized an inspection for the purpose of verifying the claims about the lodging house. But in addition, they brought in the fire chief, and he's prohibited from, by RSA 153, from inspecting single-family homes, which is what this was at the time that that was issued. And it's never been changed from that status. They never made the allegation that it's a lodging house. They're just claiming that it's a lodging house with no evidence whatsoever that it is or was at the time of the raid being used as a lodging house. If they could have claimed it was a lodging house and brought some sort of action about that, then they may have had a reason to bring a fire inspector in. Again, this is according to you guys' statutes and rules and ordinances and such. I mean, I don't believe that, I think it's outrageous that strange people are coming through my tenant's home in the first place without any real crime actually being committed here. But do you understand that the time frame that I'm laying out, essentially they hadn't proven anything about it being a lodging house, so therefore it was still a single-family dwelling, and therefore by RSA 153, the fire chief should not have been allowed to inspect that.
Okay. Well, I'll make a determination about that based on what I hear as evidence about the basis for their asking for the warrant. So, sounds like we need evidence on these issues.
Which is why I wanted to have the hearing on the warrant.
Well, we're not going to do this twice. We'll hear the evidence that they produce that is used to support their request for the warrant. And at the time when we get to the end of that evidence, up to that point, we'll make a ruling about whether or not the case will go forward beyond that point.
So I'd still like to motion this continued until July. I've been out of town a lot, and I will continue to be traveling in the next few weeks. So I put in that motion a week ago, not heard on.
What is it that you don't know or that you don't have today to be able to proceed on that?
I just would like some more time to look through, the various evidence that has been presented. I have a stack of discovery from the city here in this case.
How long have you had the discovery?
Approximately 2 weeks.
14 days prior to the date of the hearing, Your Honor, according to the rule.
And I was out of town on business for several days through those 2 weeks.
Mr. Mullins? Any objection to the continuance request?
Yes, Your Honor, we're all here. He's here.
Well, I understand that, but.
Witnesses are here.
No,
The other issue from the city's perspective, Your Honor, is that this matter has now been going on since last July, to the extent that there is a violation at this point, and the city needs to take action to correct that. I mean, this is a life safety issue, Your Honor. Mr. Freeman has already represented the tenants in the property. He's used that word several times. The evidence will indicate that the ordinance in the city requires that if you have a rental property, you have to have proper fire protection measures in place. He doesn't have those. It's in the city's interest to make sure that that happens sooner rather than later. Yeah. Again, if property is being used in violation of the ordinance, keep in mind that there's a no trespass order issued by Mr. Freeman. He hasn't allowed us back into the property. He hasn't invited anybody into the property. We're going on the assumption that the status quo that existed at the time that the notices of violation were issued exists.
Okay, well then, does it make sense to hear the evidence up to the point where the warrant was issued to determine whether or not, in fact, it was appropriately issued?
Well, I guess that's up to the court's discretion to do. It seems to me that at that point, we're halfway through this process anyway. I would suggest to the court that the judge that reviewed the administrative inspection warrant, the material that was submitted, the affidavits that were provided, had the discretion to issue the warrant at that point. And it's moot now to determine whether or not the administrative warrant should have been issued or not. The fact was it was issued by a court of competent jurisdiction by a judge who reviewed all of the materials, who presumably was acting in accordance with his legal standard and issued the warrant.
Well, I guess my question for you on that, Mr. Mullins, is, are you saying that any time, say, a court issues a search warrant or an arrest warrant, that warrant can't be challenged at the time of trial?
Well, Your Honor, I would suggest that the time to challenge the warrant would have been prior to this point, but if the court wants to entertain the motion to challenge the warrant, that's within the court's discretion. I'm just suggesting to the court that the court would have to make a determination in retro at this point, based upon the information that was provided to the prior judge hearing the matter, that he acted incorrectly under the law.
I would love to challenge this warrant previously and had intended to do so.
Well, I'm prepared to hear the evidence that was used to substantiate the issuance of the warrant, to determine whether or not the warrant should have been issued. And at that point, we'll determine whether or not we're going to proceed any farther than that.
That's fine, Your Honor.
Okay, so why doesn't the state go forward then with its evidence up to that